Good afternoon, everyone. Good afternoon, and welcome to this hearing of the Budget and Finance Committee for Monday, June 19th, 2017. I'm Paul Krikorian, Chair of the Committee. I'm joined by my colleague, Councilmember Mitchell Englander. We do not yet have a quorum. We will momentarily, but in the interests of time efficiency, we are going to proceed first with one closed session item that we want to get out of the way before we proceed with our other items on the agenda, and that is item number 6. Is Council here on item number 6? Okay. So we will then proceed now into closed session for consideration of item number 6. We'll move so you can all relax and stay comfortable in here, and then we'll be back in open session in a moment. So we will retire now to closed session on item number 6.
Let's start with our favorite, number 6. James Byrd, deceased. Joe Hunt, successor in interest versus City of Los Angeles. You know what, your city attorneys once again took the case that should have been settled immediately, dragged it out, tried to introduce drug use evidence and bad act evidence against the decedent, and then it got referred to mediation. So apparently May 1st, 17th, there's been an offer of settlement out of an ADR procedure. And you guys just keep dragging it out. You're back there huddling, wondering what you're going to do. What you're going to do is you're going to pay these people. That's what you're going to do. And the quicker you pay them, the better. Because you're going to get lucky here that these people are going to take their money and walk away from the city and not have a federal investigation tape this place off. And that's the goal, isn't it? That's why we're all here. To watch them continue to get their $200,000 a year and stay out of prison and stay out of grand juries and pay these people off. And all of these cases on this agenda every week, suing for tens of millions of dollars every week. 1, 2, 3, 4, everything. It's millions and millions of dollars. Now, if somebody like me is white, that's different. They don't want to pay a goddamn dime. They file false charges to gain an advantage in a civil case, because that's what they did with my case. Instead of just being smart and paying it, they just keep fucking around all the time, and they just keep going back in that room back there. You know, they're recording it. You know, they're leaking that information to the Times. You can't hide. Can't hide from the media. And then we have number 4, the LA Clippers. Why would you be regarding giving them back business taxes now? Is it because they went to Inglewood and want to build a stadium and move to Inglewood? Yeah, that's what it is. That's what it is, isn't it? How much money, why don't you just be smart about it? Get Mr. Balmer in here and tell him how many millions of dollars you'll give him to stay here. Just bribe him. Just legalize bribery. Why do we have to go through attorneys and litigation and all this stupid shit? Can't we just live like humans? You want the guy to stay. You don't want him to move to Inglewood. You don't want him to build a $1.4 billion stadium. You want him to do it here. And the negotiations were going to be to build a new stadium in the San Fernando Valley. That was the negotiations, but somebody apparently leaked it, gave it to Mayor Butts, and he bettered the offer. Wonder who that is. I wonder who that is. Which one of your councilmen has a house over there, huh? You're so stupid. And that's the great part about watching it. So that's why I bring a puppet. So finally, I'll give you my little puppet like we do every week, right? Yeah, you people are puppets. Keep spending all the money, and one day you too will be bankrupt. Thank you.
Thank you, Mr. Spindler. I'd like to recommend items 8, 9, 10, 11, and 13 members for consent approval, unless there are questions or concerns.
8, 9, 10.
8, 9, 10, 11, and 13. And as you're looking at that, for the record, Mr. Englander had to leave the meeting, but Mr. Blumenfield and Ms. Martinez are here, so we have a quorum. If there's no questions or concerns, then 8, 9, 10, 11, and 12, well, 8, 9, 10, and 11 will be approved on consent. And item number 13, we're noting and filing pending further consideration on item number 12. So we'll note and file item number 13. All right, that brings us next to item number 7, and we're going to proceed.
Item number 7 is a CAO report relative to the approval of $2 million for the Los Angeles Justice Fund in partnership with the California Community Foundation, the County of Los Angeles, and other philanthropic organizations to provide legal services funding for immigrants.
Okay. Thank you. I wasn't quite there yet, but that's okay. We've got it there. I did want to invite Rob Kwan up first because he had a card both for item number 7 and for general public comment. So is Mr. Kwan available? So if you could offer your comment, please, sir, your general public comment and your item 7 comment.
I'll actually be brief. I had the privilege of clerking for the LA Public Defender a few years ago, and at the Juvenile Division they had a motto, an unofficial motto. You are so much more than your worst mistake. And just how much those mistakes matter requires a personal appreciation of the facts. I think the CAO's compromise language is tailored to provide an assurance that everyone with a truly meritorious claim at least has the opportunity to be heard out. Some of the felons people might want to carve out have decades-old convictions. Some of them served our country overseas and got into trouble coping with PTSD when they came home. This vote allows for greater empathy and due process in what often feels like a two-tiered justice system. I know it might not be politically the easiest thing to do, but I think in a time when we're going to be looking back at history quite a bit, and being asked about what we did during these years. This is a vote that we can all be proud of, and I thank you for considering that.
Thank you. Thank you very much. Thank you all for your enthusiasm, but I need to ask you to please refrain from applauding because we have a lot of cards, and if we have applause for each one, it's going to basically triple the amount of time that it takes. So if you could please, I don't know, do this with your hands or something, just so that we can keep going forward. But with that, Mr. Spindler and Mr. Kwan were the only general public cards that I have. Is that right, Mr. Williams?
Yes, that's correct.
Okay, so general public comment is now closed, and we will now proceed to the broader discussion of item number 7. So why don't we go ahead and begin with the report by the CAO. Good afternoon.
Good afternoon. Yolanda Chavez, ACAO. The report before you today outlines the CAO's recommendations for the city's proposed contribution to the Los Angeles Justice Fund, a partnership with the County of Los Angeles and area foundations that will create a fund up to $10 million to provide legal services to immigrants in danger of deportation. The fund would be administered by the California Community Foundation, or CCF. CCF would contract with qualified legal services providers to provide these services. I also wanted to note that the county is actually taking this item up tomorrow for consideration by the Board of Supervisors. And the other thing I wanted to note that these agencies will actually also be able to leverage the additional funding that's provided in the state budget of about $15 million for this purpose. So CCF is actually having discussions with the state to see how we could leverage those funds. In terms of the services, I wanted to briefly note the criteria for eligibility for these services. First, in order for these funds to not be considered a gift of public funds, it is important that the recipients be residents of the city and who have strong connections to the city in terms of family members who may be U.S. citizens, legal residents, or children who are DACA recipients. The applicants must also be low income, and so we're recommending that the household income level be below 200% of the federal poverty level. We're also recommending some priority for services in terms of populations really at risk, such as those humanitarian populations, heads of households, dependent children and victims of crime, domestic violence, human trafficking, and of course, all individuals who would be entitled to protection under international treaty obligations and other immigration laws. The proposed services, of course, include direct representation, support services, pro bono coordination and recruitment, low bono services or low cost recruitment, representation, and referrals. The one thing we're also recommending in this report is that we prioritize our contribution to ensure that 70% of the city's funds are prioritized for direct representation. What is very clear from the data, which is outlined on page 4 of the report, is that detainees who actually have legal representation are 5 times more likely to succeed in receiving a bond and being released than their unrepresented counterparts. For that reason, we would recommend that 70% of the contribution be used to prioritize direct representation of detainees. In terms of the criminal history, we've had a lot of discussion about what that carve-out should be. So in terms of what we're recommending, and it's a bit of a compromise language, I would say, just based on the differences in the discussions with the state and the county, but in terms of what the city would propose, we first aligned the language with the former SB 6, which outlined that anyone who was convicted or was appealing a conviction for a violent felony as defined by subdivision C of section 667.5 of the California Penal Code and or conviction for human trafficking, child abuse, domestic violence, and or pimping, and the legal services provider has determined that the individual has no potentially meritorious claim for relief or defense from removal. So that's the language we're proposing in terms of the criminal carve-out. In terms of public purpose and funding source and proposed agreement terms, it is critical that we develop a public purpose statement to ensure this is not a gift of public funds. And that public purpose statement is what is outlined on page 5 of the report. So that the majority, and basically it reads, the majority of the city's immigrant population are longtime residents and represent an important part of the city's economic engine. The city cannot afford the cost resulting from detention and deportation and related actions. This population must feel safe and supported when accessing city facilities and programs and in their interaction with law enforcement. By providing funding for legal representation, the city will continue to bolster public safety and the city's economy. In terms of the funding source, I think you're all aware that $1 million is actually or was approved in the budget, pending your approval of these recommendations. Page 5 outlines how we would recommend the disbursement of these funds. Again, this is a $2 million commitment over 2 years. So the first $500,000 would be dispersed shortly after the start of the year once CCF has issued their RFP to select the qualified legal service providers, and once we have executed a contract with CCF. Also on page 5, you will see the other additional agreement terms to protect our funds, to ensure that CCF issues a competitive competition to select these service providers, and to ensure that the city has the authority to change the design if needed. I would also stress that, of course, the disbursements schedule on page 5 is all contingent on expenditures and performance by this program. In terms of oversight and reporting, on page 6, we outline some of the information that we would require from CCF and the detailed monthly reports that we would expect. There would also be an independent program evaluation to assess really the efficiency and fiscal and economic impacts of this program, and that would be started within a year of the program launch. And the additional matters that are outlined on page 6 and 7 are really all questions that the city attorney helped us to resolve in terms of the gift of public funds. And as I said earlier, part of ensuring that this is not a gift of public funds is to have a strong and focused statement of public purpose, which I outlined earlier, and again is outlined on page 5. The other issue was whether we could do this as a sole source contract with CCF. And again, we are able to do that as long as you make the findings, and that's one of our recommendations. The other issue that was raised was the issue of legal liability. And based on the city attorney's opinion, given that we are contracting with CCF, the city would not have liability in terms of the legal advice or representation provided to program participants. And finally, the Charter 1022 exemption, which we are requesting not because it is needed, but just because we want to be, to ensure just as part of an abundance of caution that we do that. In terms of fiscal impact, again, this is a $2 million commitment over 2 years. And with that, I just wanted to outline the recommendations that we're asking that you approve, and that is that you authorize the CAO to negotiate and execute an agreement for a 1-year term with 2 one-year options to extend with the California Community Foundation, not to exceed $2 million, dispersed on the schedule outlined in the report on page 5, for the Los Angeles Justice Fund, and of course subject to the city attorney's approval as to form and legality. 2, to approve the proposed program framework, eligibility criteria, recommended priorities for the Los Angeles Justice Fund, including prioritizing at least 70% of the city funds for the provision of legal services for individuals who are detained and who are otherwise unable to afford or have access to legal services. 3, that you approve the sole source findings as outlined in the report, and that you authorize an exemption from Charter Section 1022 as described in the report. And with that, I'm open to your questions.
Okay, very good. Well, I'm going to have some specific questions and comments about the report. I think it would be valuable for us to hear from the public before we get to that. But I do want to say to thank both the CAO's office and the city attorney's office for having resolved to a great degree a lot of the larger concerns, the philosophical and otherwise, that I've had about this policy. I do think that we are very much on the right track, but I am going to have some specific items to go over with you, but I'd like to go first to the cards. So I'm going to call up 3 people at a time. If you could just come on, and we have 1 minute per speaker in committee, so I'm going to ask Apolonio Morales, Gilbert Saucedo, and Caitlin Bellis to come up first, please. Good afternoon.
Good afternoon. Thank you to the members of the Finance Committee. My name is Apolonio Morales. I'm the Political Director for the Coalition for Humane Immigrant Rights, CHIRLA. We believe that the city's LA Justice Fund will help assist low-income immigrants, families with legal representation. In California, there is a lack of infrastructure to provide legal services to low-income immigrant families, despite the taxes that they pay. According to a report by the Urban Institute in California, the ratio of nonprofits that provide legal aid to immigrants to potential undocumented clients is 1 to 22,973. For this reason, the Justice Fund, while limited in scope, would be essential in assisting low-income immigrant families with legal representation. The city and the county announced the creation of the Justice Fund quite a few months ago, and we believe that this is the right thing to do and to go with the Immigrant Affairs Ad Hoc Committee motion. Lastly, we thank the City of Los Angeles for recognizing the economic contributions of immigrants. Thank you.
Thank you very much. Our next speaker is Gilbert Salcedo, followed by Caitlin Bellis, followed by Maria Mello.
Good afternoon. I'm Gilbert Salcedo. I'm co-president of the National Lawyers Guild LA chapter. I'm a constitutional law attorney, and as a civil rights attorney, we focus a lot on constitutional principles. The principle of due process is fundamental in the American jurisprudence, and as such, I think it's very important that this issue is being taken up today. Immigration law is very complex. I'm not an immigration lawyer, and I've been to some proceedings in immigration. I don't even understand some of those, what's going on there sometimes. So we cannot expect somebody who doesn't speak the language and does not understand the American legal system to understand it. So I think we cannot say that somebody is having a fair trial when they don't have an attorney to help them in an immigration and a deportation proceeding. So it's really important that this gets passed quickly. The CAO has put forth a very good report. We would prefer it to be universal, but I think with the exception they have, we can live with that. I would urge that this committee approves it immediately or as soon as possible.
Thank you. Our next speaker is Caitlin Bellis, followed by Maria Mello, followed by Rabea Sen. And I'd ask you to just come on up when I call your name. Come on up and grab a seat.
Maria had to step out, so...
Will she be coming back, or?
I don't think so. She had to go to a meeting.
I'll call her name later, just in case.
Thanks.
Go right ahead.
My name is Caitlin Bellis, and I'm an attorney at Public Counsel. I represent detained immigrants in their removal proceedings, and had the pleasure of working with this coalition. I would like to speak today about the existence of other programs around the country that already do this. In New York, they have had for several years now a program in which every immigrant who's detained and in removal proceedings in the city has an attorney paid for by the city, anyone who can't afford one, that is. And I think what's been remarkable about that is the transformation that's had in the lives of New Yorkers, but also in terms of the immigration courts. They're seeing better results, better law, and more hope. We have a colleague from Human Rights Watch who goes around to detention centers around the country, and she said that while in every other detention center there was a sense of desperation, in New York that desperation was absent. We would hope the same for Los Angeles. So.
Thank you. Our next speaker is Rabea Sen, followed by Victor Narro, followed by Sujana Crowan, followed by Falsok. Good afternoon.
Hi. I am Rabea Sen with Esperanza Community Housing, and we're here to thank you for considering this and to urge you to please endorse the proposal in the CAO report. Specifically, as an advocate for survivors of gender-based violence for over 20 years, I know and my colleagues know that this is especially important for immigrant survivors. Too often we see many undocumented survivors of domestic violence, sexual assault, sexual trafficking, actually finding themselves in extremely vulnerable situations where they may actually end up with convictions. And this is because of the coercion, the power, the control in those situations. It could also very well be that they've been forced into homelessness. And we all know, especially from the LASA report that showed an increase in homelessness, what this might mean for immigrant survivors on the streets. So with that, again, we strongly urge you to please adopt the language in the CAA, in the report, so that we can continue to keep all survivors and their families safe. Thank you.
Thank you. Our next speaker is Victor Narro, followed by Sujana Crowan, followed by Falsok, followed by Graciela Lopez Marquez.
Good afternoon.
Good afternoon.
Thank you for this opportunity. My name is Victor Narro. I'm project director with the UCLA Labor Center. I just want to welcome and applaud the leadership of this committee. I know this has been a long struggle to get this LA Special Justice Fund moving forward, and I really do appreciate the leadership. And also, we really encourage you to follow the CAO recommendation. I think it provides a basis for a workable LA Justice Fund. We're a coalition of 70 organizations, interfaith group, labor, civil rights, immigrant rights organizations. Now all of us are going to be here to testify today, but the ones that are here, I want to ask the groups to please stand up. Okay, thank you.
Thank you. All right, our next speaker is Sujana Crowan, followed by Falsok, followed by Graciela Lopez Marquez, followed by Brenda Gutierrez.
So, like Victor, we'd like to thank the Budget and
Sorry,
Finance.
one second. And Mr. Nato, if you're done, if you could make the seat available for somebody else. Thank you. Sorry, can you start your time over again, please?
Funny.
Thank you. Go ahead.
We'd like to thank the Budget and Finance Committee for taking leadership on this issue and approving the funds. I know it can sometimes be easy to look at this as numbers and politics, but the fact that this fund is going forward, and ideally with the recommendation from the CAO report, will mean the world to our communities and those community members that before this lived in fear every minute of every day that they would be separated from their families, thrown into detention, and deported without ever having a shot at due process. In that vein, we do hope that the Budget and Finance Committee will endorse the CAO report. We believe very strongly, as most of you know from meetings with us, that we believe that the compromise language will allow us a chance to help those that are often greatest at risk, most of whom have been disproportionately affected by the criminal justice system and the injustices that exist in that system. LA's immigrant community is looking at all of you to take a strong moral stance for them, as you have done in the past, because to a lot of them, this fund could mean the difference between life and death. Thank you.
Thank you. Our next speaker is Falsok, followed by Graciela Lopez Marquez, followed by Brenda Gutierrez, followed by there's a card with no name from someone on Swinton Avenue. Go ahead. It's okay. It's all right. You don't need to. Go ahead, sir.
My name is Paul Sok. I was brought to the U.S. as a child of a refugee in 1981 at 61 days old. My parents ended divorce, and I was raised by my father. In 98, he passed away when I was 16. I went unsupervised. I wound up in the streets. I was tried as an adult for juvenile offenses during that time, and I was given 23 years, 8 months. SB 260 in 2015, I appeared before the board, and out of 400-plus non-lifer hearings, I was one of the under 20 that were released, and when I was released, I faced ICE. When I faced ICE, I went into deportation proceedings, and I immediately received this deportation order because I was unrepresented. And when I got out, pending my deportation, while I was released, a nonprofit attorney stepped in, and when they told me to follow up for a supervision follow-up, I was actually re-detained. And when they stepped in, I was able to get this rescinded, and that's what representation does for us. And so when you place us, the exclusions, it makes it difficult. It tells me that anything that I do is not worth anything in the community. I do volunteer work. I'm now with the Youth Justice Coalition, and to face the government and even our families that are indigent, to face those resources that the U.S. has in full, that's not justice. Because we're standing there alone against everything that they have. That is not justice. How is that justice?
Thank you. Our next speaker is Graciela Lopez Marquez, followed by Brenda Gutierrez, followed by you, sir.
Hi, good afternoon. My name is Graciela Lopez, and I'm with the California Immigrant Policy Center. I'm here today to urge you all to vote in favor of the $2 million allocation to the LA Justice Fund as outlined on the CAO report. As someone who has experienced immigration detention firsthand, I know the drastic results that come from lacking legal representation. The only reason why I was able to be released was because my family was able to pull up the money and able to hire an attorney. When I was detained, I experienced firsthand the human rights violations that took place. I actually witnessed detainees being handed orders of voluntary departure and being tricked into signing those orders without fully explaining to them what that was. I'm here today to also urge you all to make sure that those who are detained are included in the LA Justice Fund, as these are the folks who are in danger of being unjustly deported. Thank you.
Thank you. Our next speaker is Brenda Gutierrez, followed by, what is your name, sir?
Carlos Amador.
Okay, by Mr. Amador?
Amador, yes.
Okay, followed by Andres Kwan.
Hi, my name is Brenda Gutierrez. We are in the middle of a crisis with the federal government targeting immigrants, ramping up immigration enforcement, and undermining the basic due process right of immigrant community members. We need the city to support our immigration communities in the face of this crisis. We need the city to continue to demonstrate the leadership that it has already shown in establishing and funding this program. I have witnessed firsthand the fear in our community, and I can see it increasing since the election. In just one example, a couple of weeks ago, I came upon a family being harassed by a group of individuals only based on their perceived immigration status. Grown men calling a 7-year-old an anchor baby. When the cops got there, the family decided to not make a report out of fear of their undocumented status. I myself found myself temporarily in handcuffs trying to protect this family. Our community is in need of leadership. They need to feel that our city will protect them. The values of the city is to defend the immigrants in this city regardless of their status. The LA Justice Fund will do that. We are better than the hate that surrounds us. Thank you.
Thank you. Our next speaker is Mr. Almador, followed by Andres Kwan, followed by Meath Soni, and then if Maria Mello is back, it'll be her turn. Good afternoon, sir.
Thank you, and thank you so much for taking up this item. Carlos Amador, I actually am a constituent of the 12th district, so you can let Councilmember Mitchell Englander know that I am in full support of an inclusive LA Justice Fund. Also want to recommend for this committee to endorse the CAO's report and endorsed model to ensure that we have an inclusive service model to represent and prioritize people in detention, as well as making sure that people that have meritorious claims are able to have a chance at the court really when they're fighting many oftentimes very well skilled, very well experienced prosecutors that are coming from the Trump administration. So I ask for your support and really showing the leadership from the LA City. Many other cities and counties are taking this item as well, or this issue as well, and what beautiful would be for the city to take a strong, bold stand for an inclusive model. Thank you.
Thank you. Our next speaker is Andres Kwan, followed by Meath Soni, and last chance for Maria Mello.
I'm Andres Kwan. I'm an attorney at the ACLU. As you know, these times pose a most serious threat to our civil liberties. The ACLU testified in this very room before the LAX Airport Committee following the Muslim ban. We saw firsthand then what this administration can do to attempt to dehumanize our fellow human beings, and Trump's deportation machine is upon us as mercilessly as ever. History will ask each of us what we did to respond to today's unparalleled crisis. We urge you today to affirm and protect the due process rights of all of our immigrant Angelinos and their families. You can do this by fully endorsing the CEO report, which the Immigration Committee has endorsed unanimously. This will ensure that the LA Justice Fund serves everyone who has a possible defense in immigration court. In particular, this will help ensure the veterans facing deportation get representation. At the ACLU, for over 2 years, we've worked with veterans who serve heroically and honorably in our armed forces, risking their lives only to come home without support, often with PTSD and substance abuse issues, due to which they have often committed crimes. The majority came here as toddlers and thought that by serving they became citizens, only to find that they would be deported after pleading guilty. Please endorse the full CEO report. Thank you for your consideration.
Thank you very much. And it appears that our last speaker will be Meath Soni, unless Maria Mello has come back. So, go right ahead.
Hi, good afternoon. My name is Meath Soni, and I'm a directing attorney at the Immigrant Defenders Law Center. We are the largest pro bono deportation defense provider in Los Angeles. We currently represent more than 700 immigrants in removal proceedings, but our representation is currently limited to very special populations, such as unaccompanied minors and adults with mental health competency issues. Unfortunately, we receive dozens of requests on a weekly basis from desperate family members of individuals who've been picked up and hauled off to Adelanto or other remote detention facilities. We cannot accept most of these cases given our current limiting restrictions. These families are then left without any options because there are so few other organizations that represent immigrants, and there are no other large-scale programs. The need is clear. And as someone who has personally overseen a high-volume program at local detention facilities, I can tell you that ensuring the LA Justice Fund is an inclusive program with limited carve-outs will result in the most efficient, sustainable program that will help the most Angelinos. Thank you.
Thank you very much. And thank you all very much for coming down and providing your comment. I'd like to ask the CAO's office to come up again because I know that we'll all have a number of questions. So I want to start again by thanking the CAO and his staff for the extensive amount of work that you've put into this and in attempting to respond to the myriad policy concerns that have come up from this committee and otherwise with regard to implementation of this fund. I think we demonstrated by the fact that we included funding for this program already in the budget for the coming year that this committee has determined the need for this funding, and the question has been how do we implement it. And so what's before us today goes very far, I think, in helping to direct that discussion. So thank you again to you and to the city attorney for helping us to get there. I guess what I'll do is just kind of go through the report section by section and offer a few comments and questions if I could. And then I'll turn it over to my colleagues for questions that they may have as well. The priority for services that has been defined in page 3 includes many categories of particularly vulnerable populations. And I think notable by their absence would be refugees and asylum seekers. And I'm wondering if those are encompassed already in the last phrase, entitled to protection under international treaty organization.
Correct, yes. We would also include it in humanitarian populations and the treaty and international treaty obligations. That's where refugees would be included.
So we would anticipate that would anticipate anyone who is seeking refugee status or seeking asylum for, political or other religious reasons.
Exactly, who may be in process and is in danger of removal.
Okay, good. Now, I guess one of the biggest issues is eligibility based on the criminal history, and I think we heard a lot of positive commentary about this compromise solution. And I will say, I think the proposed language is, to be sure, imperfect, because there will undoubtedly be people who will be caught in the exclusion who, if we looked at them as individuals rather than in a definitional way, we would say that's a person we would really like to help. Somebody who maybe had a violent offense 25 years ago in youth, and since that time they've been an upstanding member of the community, for example. On the other hand, there are going to be people who have been convicted of felonies that aren't defined as violent felonies in California, but I think most people would have very significant concerns about. Somebody who is a lifelong drug dealer, for example, who would not be captured within the definition of violent felonies within California. So this is an imperfect definition, but we have to have some definition. Unless we were just to make this universal. And because this has been such a big discussion, and I know, there's a lot of people who are still saying universal, and let me just provide my viewpoint on that. If the state law were to provide universal due process representation, I would not find that to be a troublesome policy. But the city is differently situated, because the city has never been a guarantor of legal representation for anything. The only due process constitutional mandate that the city has ever had in anything is as a prosecutor of crimes. So we do not provide legal representation for people accused of misdemeanor crimes. We don't provide a public defender's office. We don't provide free public legal advice for those who are victims of domestic violence and seeking restraining orders. We don't provide representation for people who are being evicted from rent-controlled apartments under the city's rent stabilization ordinance. So this is entirely new ground for the city of Los Angeles to be embarking upon. So I see the moral imperative of doing that. But to be clear, this is not a constitutional or legal issue at all for the city. It might very well be for the state government or for the county government. Might very well be. And somebody, I'm sure, will test that in the courts, and they should, because the cases that we hear about people who are facing imminent deportation on the flimsiest of evidence, because they don't have representation, are heart-wrenching and horrid. It's just that that's never been the city of Los Angeles's business before now. So we are, embarking upon this path, I think, for entirely humanitarian reasons. And that being said, this definition is never going to be adequate to meet our needs to distinguish how we should best prioritize the expenditures of the city taxpayers' funds. That being said, this approaches a balance, I think, by focusing on what most people would be most concerned about, which would be the violent crimes. Now, to get down to a little bit more specifics,
I'm sorry, Councilman, can I just add? I mean, I agree with you that it is a humanitarian issue, and we're doing this for humanitarian reasons, but I would also argue that we're also doing it for economic reasons.
Yeah.
The reality is that when businesses lose workers because of deportation, when families lose the breadwinner in their family, and children end up in foster care, we all have to pay for the safety net, for the foster care system. Businesses have to pay for the turnover cost of training, rehiring. So I would argue that we're also doing it to ensure that our economy continues to thrive.
Sure. One could make a similar argument about all the other areas that I described as well. But you're right, and this definition also meets that need as well. Because for somebody who, is an upstanding member of the community, which is the vast majority of people, I'm sure, who will get this benefit, there is clearly a benefit to our city, to our local economy, to the stability of our neighborhoods and everything else that comes from this. So I agree. That is not necessarily the case. We do not derive that city benefit if the person is a serial violent felon. We don't derive any benefit from keeping that person in our community, in my view. So that this helps meet both of those needs. The intent was to track the language of SB 6, and you did note, I noticed kind of in passing, the former SB 6, because this language no longer tracks the bill language of SB 6.
Right, and actually SB 6 is no longer going to be considered because of the funding that was included in the budget. So the sponsor of SB 6 will be pulling the bill.
Okay. As of now, there's legislation pending. Right. And as of now, the current version of SB 6 deletes this language about the legal service provider having determined that the individual has no... First of all, the language we have is kind of the flip side of what was in the state language. In the state language, it originally provided that the exclusion would apply only if the legal service provider determined that the individual has a potentially meritorious claim for relief or defense from removal. That's been stricken from the bill, and I would suggest that similar language should be stricken from our recommendation as well. First of all, because it makes no sense to me. I don't understand what it means to say that the exclusion only applies if the legal service provider has determined that the individual has no potentially meritorious claim for relief or defense. To me, I don't get what purpose that serves, but since it doesn't track the state bill anyway, I would just strike it.
So I'm not an attorney, but I'm going to attempt to explain why, in discussing this with several of you and of course members of the advocacy community here present, why it was important to give the attorneys really the flexibility to review each case. So to give you an example, one of the I guess best examples we received as to why you want to have a language that would allow the legal provider that even though someone had committed a felony could maybe still be eligible for relief from deportation was a case of a human trafficking victim who was forced to be part of a robbery. And in that situation, this individual was the victim of a crime, but then forced to basically be a perpetrator of a crime. So they were convicted of or charged with or convicted of a felony, but because of the situation that they were forced to be part of this criminal activity as a human trafficking victim, that person, that woman was able to receive or claim that there was a meritorious claim for her remaining in the country. And so the language is really there to provide that flexibility to attorneys to review each case and assess whether there is some claim for the individual to remain. I mean, these are very difficult situations, and we wanted to be able to provide legal service providers with that ability to assess the case, because these cases are very unique, and I'm sure the attorneys here present who practice this type of law can give you numerous examples as to why this language would be needed.
Yeah.
But that's the reason why it was included.
But the problem with that is that the attorney who's seeking to represent that person is not going to represent a person who has no potentially meritorious claim for relief or defense from removal, because otherwise there would be no basis for the representation. So in every case, the legal service provider would be able to say that there is a potential meritorious claim or a defense from removal, which would completely invalidate the exclusion. So to me, that language as it's written is not acceptable, and I suspect that's why this parallel language was stricken from the state legislation as well. And, you know, if that were the intention, at minimum, it should be an affirmative representation by the legal services provider that there is some potentially meritorious claim for relief or defense, and some reason to disregard the previous invalidating violent felony. If you don't have those two, the entire thing it has no weight. The exclusion has no weight then. So, and I will take one step further. This is only as to the city's portion of the funding. What we're saying in this does not prohibit the fund from continuing to represent that person. It's a question of whether the city's money is being directed towards that. So how the fund wants to prioritize among those cases is up to the fund. But no, we can't. No, I'm sorry. No, we can't. No, we can't. Sorry.
So maybe we could.
No, sorry, you're disrupting the meeting, sir. I'm sorry. You have to have a seat.
So would you? So maybe we could have the city attorney maybe respond. I don't know if Mike would want to comment.
Sure.
So I just want to say Mike Dundas was very helpful with the drafting of this report on the legal issues.
Mike Dundas, City Attorney's Office. I would make the same comments that the CAO's office made with respect to the.
I'm sorry. Excuse me, sir. We've got to be able to focus on what's before us now.
The purpose, I believe, and we weren't involved in the policy discussions that the CAO's office was and the research that they did when putting together the report. But the idea was to allow for the flexibility of the program to have the same, to allow that type of person to be able to achieve or to obtain access to the funds or to the legal services provided by the funds. I understand that your position with respect to possibly changing the language into the affirmative to make it a finding that the program attorney would have to make in order to provide the service to eliminate the exclusion. But that was the policy position that was taken by the CAO when they put together the report.
Okay. But, I mean, maybe I'm not clarifying it well enough, but this is a requirement for the exclusion to apply.
Correct.
In order for the exclusion to apply, the legal services provider has to determine that the individual has no potential meritorious claim for relief or defense. I don't think that's what anyone's intention in the state legislature or among, the council members was with regard to this exclusion. The exclusion applies to using city money to defend those who have violent felony convictions. Now, if we want to craft some way that even those who have violent felony convictions could appeal to use the city funding, with some restrictions, that would be one thing. But this language doesn't do that. This language completely throws the exclusion out.
So we don't believe it does, because if you don't have a meritorious claim, then you wouldn't be represented anyway. If you were
exactly,
felon.
That's exactly
the point. So, but this allows again the attorney the flexibility to review the case, to assess whether there's a more meritorious claim. I mean, you gave the example earlier: someone committed a felony when they're 14, 15 years old. they now are 50 and have lived productive lives, is there a meritorious claim for them to remain in the country? So that this language gives the attorney the flexibility to assess that. And because these cases are so unique and challenging, language, I mean, we went through this with many different versions and using the state language, but it doesn't, and we actually added additional categories here, right, that the state language does not have. But we felt that this at least gave the attorneys the flexibility to assess whether someone really had merit for staying in the country and that they could defend
I get it. But just to simplify matters, this language is not part of the recommendations of the committee. It's presumably intended to be part of the eventual contract that would be negotiated and signed. I think I just need to make clear that my support for this committee's report would be that needs to be clarified so that if we're going to do anything other than track the current language of the exclusion in SB 6, that needs to be, I wouldn't be able to support the contract that had language like that would completely eliminate the validity of the exclusion. So,
Mr. Chairman, my understanding with respect to the state amendment was not to remove the bill or remove the language, the clause, because it was inoperable, but to remove as a policy decision to draw a bright line with respect to the exclusion. So if, depending on the policy decision of this committee, additional language could be drafted for a committee recommendation that made that clear or removed it entirely. But there's a possibility to rework the language to match maybe what you believe would be the desired goal that isn't so necessarily so unclear.
Yeah, and to be clear, we don't need to wordsmith it now.
Correct.
Because that language is not part of the recommendations. I just want to highlight the issue, and maybe before the contract is finalized, we can work out something that makes a little bit more sense than this does to me at least. Going back up for a minute on the prioritizing direct representation for detainees.
Mm-hmm.
The CAO has recommended a percentage that at least 70% be spent on detainees. And I actually, guess it's just a question. Shouldn't that be left up to the fund? I mean, in this case, I kind of don't realize why it's in the city's interests one way or the other to prioritize on a particular class of representation. I would think that if the fund wants to spend 100% on detainees or 10% on detainees, the city's interest is not different in those cases. They may have a reason for prioritizing one class of clients over another, but I'm not sure if I'm seeing why it's in the city's interests to prioritize, and if so, why that percentage?
Well, I'm sure the foundation would like the flexibility, but one of the things that we wanted to ensure was based on the data, and again, the economic impact of deportations was that the majority of the money be spent on direct representation for detainees, and we wanted to ensure that, because as you look at the list of services the foundation proposes to provide, is that one of the things we did not want is that a lot of the money be spent on other administrative services.
But you could achieve that by saying 70% on direct representation, period.
Right.
And
we would not have an issue if you wanted to do that.
Okay.
The county, I think, is making a recommendation on direct representation, not just representation of detainees.
Okay.
But
I'd actually be comfortable in just sort of making that a goal or something, leaving it up to the fund to decide, but I appreciate what you're saying about the need for direct representation rather than administrative costs or those sorts of things. So, and I would expect that actually if it's going to be just direct representation, the percentage would even be higher than that. Certainly wouldn't want to have 30% spent on administrative costs.
Or other, recruitment of pro bono and other things.
And see, we would get the benefit of that from their reporting obligations. We'd be able to see with our monthly reports whether we're getting a cost benefit, whether they're spending appropriately on representation as opposed to outreach or something, right? I mean,
Right, exactly.
okay, so that brings me then to the reporting obligation. These reporting categories that are described on page 6 of the report, the items that are to be included in the report, seem like valuable things for CCF to have from the individual providers. And they'll be valuable to us as well, but they don't necessarily get to all of the things that we would want to have, I think, to provide proper oversight. Number one, there's nothing in here that indicates that the city's funds are being spent on the city's priorities and eligible beneficiaries. So I would expect that to be part of the report. I'd want to know what results are being achieved, not just how many people came through the door, but are we actually getting positive results for them? Are there, are people, what percentage of people are still being deported despite this representation or being protected from deportation? So I'd want to have some results. I don't necessarily want to ask lawyers to bill hours if they don't have to, because I've been there and I hate it. But if there's some way that we can get an indication of cost efficiency, and I think you touched upon that already by distinguishing direct representation from administrative costs, that would be a helpful part of this report back. And then I think having some general report about client profiles, so we can assess where there's additional needs, just basically the various categories, for example, that you prioritized in the report at the beginning, the particularly vulnerable populations. What percentage of the money is being spent on those individual vulnerable populations, for example? I think those should be parts of the report as well. And then just a couple of real small clarifications, and this is just the lawyer in me. But page 7 of the report, under legal liability, I appreciate the city attorney's analysis that this does not create any potential for legal liability arising from the representation. But this is just a small wordsmithing thing. The report does say that the city attorney has opined that the policy decision to provide legal services must be distinguished, etc. To be clear, so that the world is clear, the city will not provide any legal services under this program. The city is not providing legal services, and we need to clarify that in the report, in this committee's report, to make sure that there's no question the city is not providing legal services. We are providing funding to third-party providers of legal services. There's a big difference that needs to be crystal clear in the report. And then on the Charter 1022 exemption, similarly, I get the need to do it as a belts and suspenders way to protect us, but I think as we do it, maybe in the language of this committee's report or otherwise, we have to make clear that by doing so, there's no implication to be drawn from that whatsoever that the city is undertaking any fiduciary duty to the clients, any duty of due care to the clients. There's no attorney-client privilege. There's no work product privilege. There's none of that. None of the trappings of representation arise or can implicitly be assumed to arise from the fact that there's a 1022 exemption as part of our action. So I want to add belts and suspenders onto the belts and suspenders and make sure that we're clear about that. And I think I think that's all I have. So for the only change really in the recommendations then would be I would just go ahead and strike the 70% requirement from the recommendation on recommendation number 2, and then we'll incorporate a concept similar to that in the reporting obligation and what we consider the city's goals to be. All right, members, Ms. Martinez?
Sure. have a few questions. Has CCF already issued an RFP for representation?
They're not yet. They're actually waiting for the approval of these policy decisions by the city and the county, so they could incorporate those into the
county's voting
RFP.
on this tomorrow?
Yes, tomorrow.
Do you know if their guidelines are similar to the ones we've adopted or we're going to adopt?
They're very similar. The issue on representation is, I believe, the latest discussion is that 100% of their funds would be used for direct representation.
Okay.
So that's one of the issues. Their criminal carve-out is also a little different in that it aligns with the former SB 6.
Former SB 6. And were bond hearings considered as one of the proposed eligible services?
I'm sorry, could you?
Bond hearings, were they considered as one of the proposed eligible services?
Yes, I believe those are.
I thought I heard you say it earlier before.
Yes.
Where is that on the report? Because I couldn't find it.
It's part of the hearings they have. They basically call it
Do you know
receiving
if
a bond and being released.
Okay. I see. Do you know if the state bill also considered bonding hearing as part of their legislation? Do you know?
So I believe, my understanding of what the state is doing is that the Department of Social Services will be drafting their guidelines based on the budget language.
The state bill language is more in the line of direct representation on all immigration issues. The trailer bill that actually incorporated this language into state law that was just recently passed allowed for pretty much any kind of immigration relief in that kind of proceeding for the funding to be used for.
And do we know if any of the nonprofits or foundations currently cover the cost of bond hearings?
I believe they expect to be the most flexible with their funding, so they would cover all relief services.
And I also had a question about, do we know what part of the funds will be used to train and develop capacity of private attorneys with the expertise in these fields? Do we know how much of that would be carved out for them?
I do not know, but I know that's one of the services that CCF intends to include.
So I was curious as to how the foundation plans to roll that out.
So the foundation is here if you'd like them to answer some questions.
So I do believe it's important to build capacity because I don't think we have anywhere near what we need. So I was curious as how you were going to roll that out.
And just while she's coming to the podium, just to your earlier question, page 3 of the CAO's report, the first bullet point under proposed services includes, you'll see in the last line, bond hearings.
Got it.
Good afternoon.
Hi, good afternoon. Rosie Arroyo, Senior Program Officer for Immigrant Integration at the California Community Foundation. And just as the State Administrator's Office has been sharing, CCF and has been working very closely with also the Weingart Foundation right now to focus on building the infrastructure for this program. And so our goal is really to have a strong infrastructure. So once the policy and the program is approved by city and county, that we can roll out the program. So as of now, philanthropy has not been, we have not taken a position on any, the policy. For us, it's really been to align and support what the city and county, approve and move forward with that.
So the funds are also being proposed to be used to subcontract with other private attorneys for certain expertise, or to build a bench of private attorneys willing to take this work pro bono. Do we know what that looks like, or what kind of expertise are you looking at outside of the attorneys you currently work with?
Yes, so as of now, the way that we're looking at the funding priorities have really been to, number one, really prioritize on really building and bolstering existing removal defense efforts so that, we know there are organizations that really have the expertise in providing removal defense services, so a bulk of the resources will be allocated towards that effort. Another portion is really to also increase the capacity, and so for that strategy, what we envision is we know that there's already a number of organizations that have been providing legal services on DACA, citizenship, and other that do have the infrastructure and ability to hire an attorney to expand the removal defense capacity. The third area that we have been exploring has been looking at enhancing and expanding access to pro bono services. So that support, we have been in touch with several experts in the field in that area, getting input from different legal service providers, advocates, professors and academia and other experts to really look at how do we improve the coordination of services. So many times organizations do partner with pro bono, but for us it's, maybe sometimes it's supporting a coordinator, somebody can really help to just enhance and at that capacity.
And outside of what our current nonprofits already do, is there a specific legal expertise that you're currently looking for that perhaps some of our nonprofit attorneys are not experts in? Is there a particular field?
No, as of now, it's really been focusing on removal defense.
Right. Okay, that's all I have.
Thank you. Mr. Bloomfield?
Thank you. Well, first, I think it's important that the cities stand up and take leadership against the Trump administration's inhumane rhetoric and policies around immigration, especially when it comes to undocumented persons who are legal permanent residents in the U.S., veterans, political asylum, folks who have longstanding ties to the U.S. So I'm 100% on board with that idea. In fact, I'd go further. I think folks should have a right to a civil defense, and I worked on legislation to that effect with our current city attorney when we were both in Sacramento. And so I'm, again, 100% behind that. My concern here is the mission creep for the city. Expanding the services that the city normally provides. And as our chair pointed out, and you made the arguments I've been thinking about, we didn't get a chance to talk about it, but this due process mandate that the city has never had. Other cities, city counties, New York, San Francisco, they have public defenders. They have that tradition of providing due process. They have a mandate. Our charter doesn't give that to us. It's outside of our scope. It is a whole new mission. So how do you reconcile that with what we're doing today? And obviously I've reconciled it in the sense that I supported the budget money that went into this. And you reconcile it from my perspective by saying this city has consistently taken leadership, and when when there's a crisis like this, we try to step up to the plate and we try to bring others along with us. But the concern is, how do we make sure that that what we're doing today is just that, is the launch, is the leadership, is the bringing folks along, but is not taking on a new responsibility that is going to compete with our very limited resources, especially as the federal government is cutting more and more resources that we spend on the very same vulnerable populations, and resources of which, as we know from the budget process, are diminishing. And this has been my big sort of fundamental conflict on this whole fund. So one thought I had in terms of trying to make this happen is to ask that we do an additional recommendation to kind of you talked about the belt and suspenders, you're talking about the same issue, belt and suspenders and maybe another belt, and to adopt a policy that funding legal representation is a core function of the county and the state and not the city of Los Angeles, and that the city will make a commitment to help launch the Justice Fund, but not commit to sustaining it beyond the recommended time frame. I'm not putting a hard stop on it because I want to encourage this to be ultimately a sustainable fund that will be funded in perpetuity. I want it to be expanded to not only cover everyone who's risking deportation, but ultimately to cover other civil issues, foreclosures, and all these other things. But ultimately, I want it to go where it's supposed to go in terms of the lane, which is at the state or the county, or as most things are, a state-funded, county-administered program. So I thought by putting some language into that effect, that is making sure that we're not a hard stop, but just making it extra clear, because my fear, as all of our fear is going to be, is that a couple years from now, we're going to be up against this question, or are you going to cut this money? And that's not the dynamic that we're looking for by putting this money out. We are looking for the dynamic that we are launching, but it is not, we want to make it very clear that we're not committing to sustaining this fund over a long time frame. Unless we change our charter, we change our mission, and we with open eyes change our mission, accept that mission change. But we haven't done that, and that's not what I'm intending on doing by supporting this. So I'm supporting this, but I want to make it extra clear of what it is I'm supporting. So that's why I wanted to add that extra language in, Mr. Chair. So that's one thing. And then the other thing I just wanted to tease out, and I know you said it's not going to be one of the recommendations on the what that meritorious claim issue is, but I wanted to tease that out with a question about that second part that was proposed by the CAO, and that is, what is a meritorious claim? It's really a question I'm asking out of ignorance. I'm assuming it's something more to do with your relationship with the U.S., like you have 2 kids and you've been here 40 years, than it does with the crime that you've committed. I think it's relevant because as we decide whether that's going to be a way to create an exclusion. So, for example, if somebody has been committed of a violent felony and they've done heinous, horrible human trafficking things, and they're not the kind of person we want using this funding, but they have 5 kids who are in the U.S. and maybe they have a lot of meritorious reasons to be in the U.S., would that meritorious claim still apply? Or is it diminished by the fact that they've committed a heinous crime?
Well, there's a number of factors that go into the analysis of how you would be deported. It's a very complex system, and that's part of the reason why I think the city is considering this proposal to be able to provide people with counsel when they're faced with these decisions. The likelihood of success is based on any number of things. So there are certain crimes that when you commit that they're generally seen as sort of by right deportation provisions, or excuse me, by right deportation provisions. But it doesn't. I can't just say that you commit a certain crime and you're automatically sent home, or if you have a certain family member, you'll get to stay. It's a complex analysis that the attorneys would have to conduct to see, do you have a likelihood of success in staying in the country and finding a reason to prohibit or prevent the deportation. There's no simple answer that can be given other than the purpose for what it was put into place was to give the program the opportunity to not foreclose. And I guess in the chair's example that he gave in the beginning, which is you committed some crime 25 years ago, you've basically been you've been living your life and contributing to society, paying taxes, that kind of thing up until that point in time. And then you come across the deportation system and you have an opportunity to be able to say, I can get representation because the attorneys in this program think I have a likelihood of staying despite my prior criminal record. And therefore, rather than being excluded as a bright line, I have an opportunity to still get to stay because the law would allow me to stay otherwise.
But the meritorious claim has to do not so much with the crime, but with your family situation.
Well, it could be any number of factors. I mean, there's asylum claims. There are family factors. There's the DACA program. There's any number of things that may contribute to your ability to be able to stay, separate from just having committed a crime and you either go or you don't go. It also depends on what crime you've committed as well.
So I do think, there is a utility to having some sort of extenuating circumstance provision. I agree with your reading of it in terms of how this could completely preempt the first half of the clause of a compound clause like this, but maybe we still have some work to do to try to figure out what that extenuating provision clause could be.
And maybe a simple way to do it is to just put the onus on the legal services provider to explain what the reason for an exceptional treatment should be. I'm just pulling that phrase out. That has no legal significance. But if there's somebody who would otherwise not be an eligible recipient of city beneficiary of the city funds, and there's some good reason that the legal service provider has for making an exception to that, then maybe they need to articulate it, document it in some way, and then they're held accountable for it after the fact when we evaluate it in the reviews. But what you can't have is a situation where it's the reverse of that. And the legal service provider is the one that's getting paid is the one who is making the decision to say, well, I find that there is no meritorious claim, and no, because they wouldn't be doing the representation if there weren't.
So if maybe we change the language to say, if you found that a case had a meritorious claim and you represented them, please explain what was the outcome as part of the reporting process. Would that be something helpful, or would you feel comfortable with a process like that, where if the legal services provider, after analyzing the case, felt that although there had been a crime committed, that the individual was still worthy of representation because of a meritorious claim, and then have them report that as part of the reporting they do to the foundation, of course, and to us? Would that make you feel comfortable? And then we could come back and report?
Yeah, I think something like that would be helpful, because I agree with Mr. Bloomfield. There are going to be situations where the legal definition that we include in a contract is not going to well suit a particular case. And we know that those are going to come up in both directions, by the way. Right. And so I think, in the interests of not denying someone assistance who is very deserving of this assistance, we ought to have some flexibility built into it, but this language doesn't do that. So, we don't need to craft it now, as long as we, get there before the times of the contract.
We're not crafting it, we're speaking to it, though, so that when you go back and craft it,
right.
Maybe the meritorious claim is not the only word, because that is that's what I was getting at in my question, can be a very specific issue having nothing to do with the crime. Your meritorious claim could be that you have 20 kids that depend on you and that live in the U.S., and that is meritorious, but you may have done some horrible thing that otherwise you wouldn't want to be defended on. So having an extenuating circumstance that there has to be a finding on, and that has to be reported, and that ultimately there's some accountability, at least gives me a little bit more comfort and creates that discretion so that you can serve folks who, in all the cases that we imagine, the asylum seeker, this and that, where, we want to serve them, is there, but we also don't take in the opposite case with the person who is, a rational person wouldn't want.
I also wanted to add very briefly that, understanding that we have to efficiently use public resources, we have also been engaging the Vera Institute of Justice, which is a national organization that has vast experience evaluating both federal and local legal services programs, to also develop a robust program evaluation for the LA Justice Fund.
The only thing I was going to add to your comment, sir, was that the idea is that it would provide an opportunity for relief for the person despite the criminal history. And so that if it could be determined that the person has a meritorious claim to stay in the country despite the fact that they have this criminal record, that would be the idea of giving them that sort of relief.
And I assume there will be cases where a detainee might have actual affirmative evidence that they were wrongly convicted, and they'll want to present that, for example, so that even though they have a violent conviction, they'll want to sort of relitigate that claim in these proceedings, in the immigration proceedings, right? I mean, I assume that so those would be the sorts of circumstances where, if in fact there's a good explanation, a good reason, if in fact it turns out that the conviction was coerced, or for whatever reason it shouldn't be considered, I would think that we would want to have flexibility to be able to accommodate those cases. But I just don't want to throw the baby out with the bathwater.
I also think it may be helpful if we provided you a list of crimes that, as Mike said earlier, if they're committed, they're deportable. There is no meritorious claim. So really, like the heinous crimes that would not even, that under this type of language, you wouldn't be considered anyway. I think that may be helpful as well for you to see.
Sure. So then I don't know, Mr. Williams, maybe you can offer your insight as to whether we need to include within our committee report a summation of this discussion as one of the recommendations. because we have the 4 recommendations. None of these actually addresses the exclusion at all. The exclusion is only contained within the CAO report. So rather
Right.
than rewriting the report, is there some way that we can capture these thoughts in our committee report?
Yes, Mr. Chair, we can capture this discussion in the summary of the report, and if you like, also include a recommendation that the CAO include some of the issues that you requested or that you discussed.
And perhaps report back at the time of council.
Right, and ask them to report back. Otherwise, the discussion can just be encapsulated in the summary. If you want to leave the recommendations as indicated in the CAO's report standing,
okay,
that would be up to the committee.
Okay, so maybe then we add a recommendation requesting the CAO and the city attorney to report back prior to the council vote on proposed language to address the need for flexibility in the case of the applicability of the exclusion.
Just to clarify with the record, would you like the report back to this committee or to council?
No, to
prior the vote?
council.
Okay.
It'll have to go to council. So.
Yeah.
Does that work?
Sure.
Anybody object to that?
To that?
Okay. All right. Anything else? Mr.
Well, I did want to make sure that we're also capturing the additional recommendation that I mentioned, if that was acceptable. That was to adopt a policy that funding legal representation is a core function of the county and the state, not the city of Los Angeles. The city will commit to help launch the Justice Fund, but not commit to sustaining it beyond its time.
I think that, you know, we can never commit future councils to fund anything, but I think, again, belts and suspenders, it's important that people understand this is, you know, we're making this decision. We're not making decisions about what may happen in the future. And so you're right. Once things are done once, they tend to become an expectation, and that we're not prepared to do that at this point. We'll see how it works.
You can include.
So I think including your language is appropriate.
I'm sorry, Mr. Chair, for clarification. Include the request that Councilmember Blumenfeld has as a recommendation, or include that as a instruction to the CAO and the city attorney to report back on including?
No, there's no need to report back on that. I think, is it sufficient that it be captured in the committee report, or as a
recommendation? If it's
okay,
possible.
yeah, we'll just include that as a recommendation.
Okay.
So, Mr. Chair, just a clarification on deleting 70%. Would you rather
thank you.
it be reworded to prioritizing direct representation?
You know what? Let's make this really simple, because in the recommendation it does say including prioritizing at least 70%. It doesn't say that that's a hard. So I'm comfortable with that. Let's just leave it at for the provision of legal services for individuals. You can strike who are detained.
Okay.
And then it could be any individuals. So I assume that CCF will focus, you know, its attention there, but there may be somebody who is here on DACA status who gets a letter from the Trump administration that says that their status is revoked and they want an attorney. You might want to represent that person. So that should be direct representation as well, even though they haven't been detained yet. So, okay. Anything else, members? Okay, so everybody clear on sort of what we've added to the recommendations? Mr. Williams, do you think you have those captured? Please don't ask me to restate it.
As far as I can determine, the committee is adopting or approving the recommendations in the CAO report, and then requesting the CAO and the city attorney to report back to council at the time this matter is scheduled regarding the exclusionary language and other issues that you had highlighted, such as the reporting back, the legal services provider reporting back. Additionally, we're going to include as an additional recommendation the request by Councilmember Blumenfeld that the city, that we make it clear that the legal representation is a core function of the state and county and not the city. And then the third recommendation, or an additional recommendation, would be to strike language relative to, that you indicated, who are detained.
Yeah, that's in recommendation number 2.
Recommendation.
CAO recommendation number 2, just strike the language, who are detained.
Okay. So that's a correction to recommendation number 2 in the CAO's existing
Yes,
report. Okay.
exactly right.
Okay, just to be specific,
Anything else?
Chairman? Yeah,
Yes.
because as it was read, it would be 2 reports. If it's okay with you to have the CAO with the assistance of the city attorney, because it was rather than 2 report backs separately from our office.
Yeah, that'd be fine. That'd be fine.
A CAO with the assistance of the city attorney.
Perfect.
Okay.
Thank you. All right, anything else? With those amendments then, is there any objection to approval of this item? Seeing none, it will be the action of the committee to approve the report as amended. Thank you all very much.
Thank you.
Okay. Yeah, but okay, so the only other only other item we have for open session now is
Item 12.
Number 12.
Item number 12 is a CAO report relative to the 4th restated professional services agreement with Hess and Associates, Inc. for continued support of the payroll system replacement.
Sorry. Good afternoon.
Good afternoon. Claudia Aguilar with the CAO's office. Before you is a report from the Payroll System Replacement Steering Committee to extend the city's contract with Hess and Associates for continued support of the payroll system, and a recommendation to eliminate the Payroll Replacement Steering Committee and to delegate the authorities previously invested in it to the Information Technology Oversight Committee, referred to as the ITOC. So amendment number 18 with Hess and Associates will increase the contract amount by $875,000 and increase the term of the agreement by 16 months for a total contract amount of $14.3 million and a total term of 15 years and 4 months. The previous amendment, number 17, initiated the baselining project, which was set to stabilize PACER to enable ITA to take control of the maintenance of the system. However, because of a number of legal compliance items that had to be pushed forward, and including memorandum of agreements, of understanding agreements, the project became a 3.5-year project. So we're asking for authority to extend that contract to enable ITA, the controller, personnel, and Bob Hess to finish the stabilizing of the PACER project, which is what the amendment number 1, recommendation number 1 is asking for that approval. The hopes is that once this baselining or now risk management is completed, the city will have a stabilized system which will enable the city to, like I said, have ITA control and also be able to go forward with any replacement project. Until such time that the system is stabilized, we run the risk that we will not be able to go forward with the replacement because of major changes that could happen to the system. So we are asking in the contract that we do not do any major changes that would jeopardize that risk mitigation project. So that is the first item. So I figure if you want to talk about the contract, then we can come back to the steering committee, just so that it's not too much information there.
Yeah, I don't know that I really have anything on the contract at this point, members. Okay.
So the next set of recommendations are actually related to the Payroll System Replacement Steering Committee that was established by Council in 1999. Right now, it's comprised of representatives from the Mayor's office, the CLA, and the CAO's office. We meet on an as-needed basis to discuss major issues within the PACER as in the actual payroll system. The recommendation from the steering committee was that we eliminate the actual steering committee itself because these issues are being looked at on a citywide basis through the ITAC, who is already reviewing the future, the HR project. So we didn't see the need to have two separate bodies of the same committee members looking at the same items. So we are asking to have council delegate those authorities. And just to clarify, the recommendations include wording that was in fact in the 1999 council recommendations. So we're still looking to keep the ITAC at a very high level. We really are only asking for changes that would affect the structure in a major way to come back to the committee. At this point, we're not looking for an everyday oversight of the committee. It's really to make sure that we keep this project online and to complete at the time when Mr. Hess has indicated he'd like to take a step back and not have the full day-to-day operation. So we're hopeful that with your assistance, we can convey the importance of keeping PACER project on track and not having any more large structural changes that can affect that integrity.
Okay.
If you have any questions, we are here to help.
I appreciate it. Members, any questions? I would only add to the recommendations that we approve the recommendations included in the CAO report, but also add recommendation number 5 that we would designate ITA as project manager and direct the department in concert with the Controller's Office, Personnel Department, CAO, and any other relevant departments to report with a staffing plan and appropriate budgetary requests to adequately manage the existing payroll processing systems. So with that addition, I would, if there's no objection to the items.
Can I just ask for a point of clarification?
Yeah, sure.
Councilman, good afternoon. I'm Georgia Matera from the Controller's Office. I know we talked about project manager with ITA on the replacement project, but on the day-to-day, in terms of the production issues, is that ITA as on the day-to-day, or are you talking about the long-term PACER replacement?
For the PACER replacement as project manager, but we're asking for budgetary requests with your analysis in concert with the Controller's Office about what it's going to take to keep the wheels on in the meantime, I guess.
Okay, and then we would report together back to the committee with both the Controller's and ITA's request.
It's a, a request for ITA's report in consultation with the Controller, and the Personnel Department, the CAO, and any other relevant department for those budgetary needs.
On the budgetary issues.
Yeah.
Okay, thank you.
Okay. All right, then, Mr. Ross, anything care to add?
No.
Okay.
I really appreciate the support of the committee.
Thank you. It's been a long time coming, so.
We thank you for your support.
So there being no objection, that will be the action of the committee. And that, I believe, concludes our open session items, and we are prepared now to resume closed session. Sure, that's fine. All right, the Budget and Finance Committee having concluded the agenda and there being no other action before the committee, we are adjourned.